Hello guys, and welcome to another episode of my lecture. And today we'll be talking about the case of Leonard Carriage Company Limited versus Asiatic Petroleum Company. And like I did for Virgin Tech and Mohammed, as well as Odutola Holdings case, we are going to see the fact on the screen and we are going to peruse through the fact together while trying to understand the reason for the judgment and how the issues were raised, how the issues were solved. So, starting with the fact, a ship owned by Leonard Carriage was transporting gas owned by the respondent to Asiatic Petroleum Company. The ship sank due to its sea unworthiness and the cargo was lost. The respondent sued for loss of cargo and the appellant relied on Section 502 of Merchant and Shipping Act, which exempted ship owners liability for loss if an event happened without actual fault or privity. Now, for us to explain, what this fact is talking about, there is a company, Leonard Carriage. There is another company, Asiatic Petroleum Company. Now, Leonard Carriage's function is to help transport gas the way we have Uber or we have delivery services that can help us transport our goods from one place to the other. So if you are at Yaba, or that's in Nigeria, or you are at another place in Nigeria like Kano or Lagos, for example, you want to transfer a particular goods from Lagos to Kano and you need a particular company, you can contract with a company to help you transfer it. In this case, what was being transferred was gas. The company that was contracted was Leonard Carriage Company Limited that helped them transfer gas from one place to the other. Now, the gas sank in the middle of the ocean because of the sea unworthiness of the ship. Now, the ship was not good. Leonard Carriage, in this case, after the ship sank, wanted to rely on the provisions of Section 502 of the Merchant and Shipping Act, which will exempt the company from any liability where the company does not have actual fault or privity, which means that the company doesn't have knowledge of any faults. Do you understand? If the company did not have knowledge, then Section 502 exempts the company from liability. Now, when they took the case to the trial court, the trial judge found that Mr. Leonard either knew or should have known of the defect of the ship, and as such, the appellant Leonard Carriage could not rely on Section 502. Now, the reason for the court judgment, Mr. Leonard was a director. Now, Mr. Leonard was basically the one that takes almost every decision in the company. However, Mr. Leonard was not the managing director. If we were to interpret this in terms of our CAMA, you would see the three people that their act can incur liability in a company would be the board of directors, the managing director, or the members in general meeting. In this case, Mr. Leonard was not even the managing director, but Mr. Leonard was the one that takes almost every action. But let us go to what exactly the Court of Appeal held in this case, especially the statement of Viscount Heldane in this case. The issue was whether the guilt of a director could be imposed on the company or corporation. Like I said earlier, Mr. Leonard was basically the one that was doing the most things in the company. So basically, the question is whether his guilt, because he must have known of the sea unworthiness of the ship. So therefore, whether his guilt for knowing that could be imputed on the company, so much so that the company would also be liable for such incidents. The House of Lords unanimously held that Leonard was the alter ego of the company and not merely a servant or agent, and there was a presumption that his action were the actions of the company, which would by extension mean that his fault was also the company's fault due to the principle of attribution. Principle of attribution is something that I'm going to discuss, but I would love to discuss it better in our next case. That's the Meridian case. I will discuss it in the next next case. But right now, let us continue. The company could not therefore rely on section 502 to claim that the loss had happened without actual fault or privity. Now, let us look at the rationale. Let us look at why the House of Lords held that. Now, Viscount Haldane said that a corporation is an abstraction. It has no mind of its own any more than it has body of its own. Its active and directing will must subsequently be sought in the person of somebody who for some purpose may be called an agent, but who is really the directing mind and will of the corporation, the very ego and the center of the personality of the corporation. Now, if you have followed my lecture, you would know that the first case I quoted was the case of Bolton Engineering versus Graham, where I told you that a corporation is like a human person that has hands and legs. The hands and legs are just basically like servants, but it must have the nerve center. It must have the brain and the mind. The brain and the mind of the company is the person that makes decision of the company. According to Viscount Haldane, he is saying that that person that is making decision for the company is the alter ego of the company, because the company cannot act on its own, because the company is an abstraction. Therefore, it needs to have a mind and body that can make decision on its behalf, and we must look for who that person is where there is a problem. Now, he also said that he is no merely an agent or servant for whom the company is liable upon respondeat superior. What that means is the master-servant rule, where the master is vicariously liable for the actions of the servant. The court here is telling us that we are not talking about vicarious liability here. Vicarious liability, if you read through the law of tort, has three elements. The first element is that there must have been a tort committed. The second element is that there must be a contract of employment between the person who is the servant in this case and the employer, that's the principal and the employee. And then number three, that particular tort must have been committed during the course of such employment. But we are not talking about torts. We are not talking about vicarious liability. What is of importance to us is to answer the question whether the act of this person can be termed the act of the company itself, which is what the court is saying here. The court further went on to say that one who uses this section to excuse himself must prove he is not the directing mind of the company. That means that he must rebut the presumption that he is the directing mind. Now, the court found that Mr. Leonard to be the natural person to come on behalf of the ship owners to give evidence of events, not only to the worthiness of the ship, but as to his position as to whether or not he is the life and soul of the company. Mr. Leonard was the active director of the company, number one. His name was registered on the company's register, number two. And he took active part in the management of the company, number three. That's the management of the ship. If he was the directing mind and will of the company, then his act must, unless a corporation is not to be held liable, be considered to have been the act of the company itself. The House of Lords held that liability could be imposed on a company for act of the directors because there is a rebuttable presumption that the directors are the controlling mind of the company. Mr. Leonard and the appellant company didn't rebut the presumption and were thus liable for the negligent act of Mr. Leonard. Viscount Haldane pointed that identification of such directing mind and will as primarily a constitutional question depending on powers entrusted to the person by the Articles of Association. Now, I love this case so much, this Lennard case. It opens our eyes to a lot of things. Very importantly, it tells us that when we are talking about someone whose act should be the act of the company, the person need not be the managing director. The person need not be the board of director or the member in general meeting. Do you understand? When you are talking about the act, we should be asking the question, whose act can be determined to be the alter ego of the company, such that when he does a thing, he binds the company. Now, when that person has been brought to court, there is a rebuttable presumption that he is the directing mind and will of the company. Except that presumption is rebutted, the court will take it that he is the directing mind. Do you understand? Where there is a casualty or where there is a liability and then somebody has been brought to the court and then the other party is alleging that this person act is the act of the company, the onus is on the person alleging that he is not the act of the company to prove otherwise. Do you understand that? However, there are also certain complexities in this case, but I want us to analyze those complexities in light of the second case that I'll be teaching, which would be the Meridian's case. Do you understand? I will also talk about Leonard's case more in depthly in the Meridian's case. So see you in my next lecture.